But you made us promise that in no season would your character ever be locked in a cage.
we all remember Savannah.
There was another promise was no pet monkey. Chuck has a matching pet monkey with coordinating outfits, and I was like, I would love to be part of the show, but I can't act with a monkey. Then I got a few of them.
She got a few of them.
Come on, it was a joke.
Who else didn't want to act in a cage?
Well, some of them
required a
started.
cage.
Yes.
Hi besties, it's Katie from Without a Crystal Ball. Welcome back to my channel. Yesterday in the courtroom, the judge told Wayfair that they could file a motion to dismiss, right? And then they responded that they could also get a judgment on fact, like a summary judgment. And I was like, well, how would they get a motion to dismiss? Well, it's because Blake Lively just filed a second amended complaint. And while she is refiling to shore up and try to clean up jurisdictional issues that got Jed Wallace dismissed, what she's ultimately done is enabled Wayfair and any of the defendants here that are in this case to individually file motions to dismiss. And at this point, each Wayfair defendant gets to decide if they want to respond to the second amended complaint. Because in the court, the second amended complaint becomes a superseding complaint. Now, they can either stand on what was revealed in the first amended complaint and not respond to the second amended complaint and just allow Jed to, or because she's brought in new facts that she claims put Jed in New York, which they don't, they can file a motion to dismiss. And while a lot of you say that you want Justin and Wayfair to be exonerated, you know, no matter what happens in this case, even if they were to go to trial, the likelihood that Blake would ever apologize is none. Because even if they won, she would still double down and say it happened. There's no winning with her. It'll be like Amber Heard. Amber Heard lost massively when she sued Johnny Depp, but she doubled down on her claims despite losing. She's not going to ever admit, Blake, that she's done anything wrong. So I'm not a lawyer, but they are very far into discovery right now, and they have enough evidence and they have enough information at this point to know whether or not she has met the burden for failure to state a claim, or if there is a legal limitation to some of the claims that she has made. There's a couple counts that they should file a motion to dismiss for because she never filed anything with the EEOC. Some of the retaliation claims are time barred in the state of California. There's a lack of her to exhaust all of her administrative options. And so with the second amended complaint, all these months later, there's no way that Blake now can go to the EEOC. She's barred now from filing a charge with the EEOC. She had 30 days from the time that she filed with the California Department of Labor. So they safely could file a motion to dismiss, and she can never go to the EEOC now. So those charges would just go away. And there's really no point to bring those forward because if they're not valid claims, they should get knocked out. And I understand from the perspective of like what Brian Friedman initially said, where he said, you know, Wayfair wants to be exonerated. They want a chance to go to court, but it's clear now that they're not planning to go to trial because they believe they can get rid of claims through a summary judgment. Well, they could also get rid of those same claims through a motion to dismiss. Both allow the claims to be dismissed as a matter of law. So do you file a motion to dismiss now, or do you wait more months and allow Blake to keep continuing on in this frenzied chaotic spell where she's literally subpoenaing 107 creators and she's desperately trying to attack and attach them to any claim? Or do you just try to like stop it now? Because a motion to dismiss with prejudice on these claims is a win. It's not a win of a technicality. It's a win of law. She can say whatever she wants. She can say that he sexually harassed her, but if she's barred by the government from bringing the claims, it's irrelevant. Doesn't matter. She can say that they retaliated, but if she's barred by the law, it's irrelevant. It's not a technicality, it's a law. And if I were the attorneys of Wayfair, and I'm saying this just in my own world, and I'm not an attorney, but if knowing what it's like to go through litigation, because by the way, I'm still 3.5 years into litigation with Robert Shin, who's now facing a federal, raid for sex trafficking, is you have a literal opportunity right now to get out of this without going to trial, getting a firm judgment that would dismiss these claims or vastly reduce the claims if you were to go to trial, getting rid of all of the claims that are irrelevant or time barred. So I think if I were, one of them, if I were Wayfair, I'd really think about filing a motion to dismiss here because she isn't adding anything new. She's trying to expand on some of these narratives, but in her second amended complaint, she's trying to tie Jed to jurisdiction that was already dismissed, that she didn't win in the motion to dismiss. So she's going to try to use the CPLR conspiracy jurisdiction, which again, the court had stated they haven't used before, but they're saying Wallace defendants committed a torturous act without the state causing injury to a person and property within the state, expected or reasonably should have expected the act to have consequences in New York and derive substantial revenue from interstate commerce. It's not going to work. And all while he was in Texas. They may also exercise personal jurisdiction over Wallace pursuant to CPLR 302A2 because the New York-based overt acts committed by the Wallace defendants' co-conspirators may be attributed to Wallace defendants who were aware of the co-conspirators' New York-based overt acts. And this is where she uses the same conspiracy claims that the judge said did not have anything to do with Wallace because they literally were done before Wallace was ever hired. They say that the New York can be attributed to Wallace defendants. A few examples, Baldoni and Mr. Heath met with her in person in New York, and she raised concerns to them of their harassing behavior on January 4th of 24. Mr. Sarowitz threatened to ruin the lives of Miss Lively and her family while attending the New York premiere. Both of those incidents, they've already stated, are not evidence of a conspiracy. The judge already said that in the motion to dismiss, and he already stated that Sarowitz making that comment isn't proof of a conspiracy. Miss Abel worked as an employee of Jones Works, which position directly gave rise to the retaliation campaign at issue. She is not an employee of the Jones Works, New York. Wayfair contracted with Jones Works for certain communications and public relations services that gave rise to this dispute in an agreement under which Wayfair consented to jurisdiction in New York. So now she's going to bring in Stephanie Jones's company as a co-conspirator. So why isn't she suing Stephanie Jones? And then Wayfair consented to jurisdiction in New York. Miss Nathan conducted business from Brooklyn during a portion of this relevant period. And the issue with this is that the judge told her that she didn't identify any relevant period that Melissa Nathan lived there. He wouldn't even address the Jones Work stuff. And she isn't actually attaching any of the actions that actually injured her. And then she spoke to one journalist, which again, they disregarded completely. He said that would be more for Melissa Nathan and Abel having jurisdiction over them, but not for Mr. Wallace. And that now they're holding that their agent and lawyer, Mr. Friedman, made defamatory statements regarding Miss Lively on their behalf, and each of the defendants' torturous acts caused injury to Miss Lively and her family. So this could be why Miss Lively wants Mr. Friedman's communications, because she wants to find out if Jed Wallace is the source. But most of these issues got her first amended complaint dismissed because they didn't meet the bar of proving conspiracy, proving jurisdiction at all. So now she's just saying, well, Brian Friedman defamed me. And so that's proof that Jed Wallace has jurisdiction. He's going to be able to get out of this a second time. This is honestly just an embarrassment. And she's allowing Wayfair now to also file motions to dismiss. And so in the actual complaint, the second amended complaint, she says, it is public knowledge that Miss Lively resides in New York with her family. However, Mr. Wallace certainly understands that Miss Lively resides in New York and was engaged in promoting the film in New York because Mr. Wallace has sworn under the penalty of perjury that he was at a minimum engaged in passive observation and analysis of the social media environment as it pertains to It Ends With Us. So she's going to use his passive observation of her social media account as proof that he damaged her. And that's why the court has jurisdiction over him. That means that this is a crazy, like, wild accusation to make, because that would make it so that any one of us that reads her social media or engages in her social media or passively analyzes it and observes it, she's claiming is enough for a court to have jurisdiction over. That social media environment was rife with posts demonstrating Miss Lively's connection to her residence in New York and the efforts to promote the film, including by Mr. Wallace and street relations co-conspirators. For example, simultaneously with Miss Nathan's initial outreach to Mr. Wallace, Miss Lively posted photographs on her Instagram account showing interior shots of her New York City apartment partly to promote the film. The post included the hashtag It Ends With Us movie as one example. On August 4th, 2024, Miss Lively posted a photograph of herself inside her apartment with the hashtag It Ends With Us movie with the caption Blue Jean Baby. So the fact that she posted photos of herself on her Instagram is proof that the court should have jurisdiction over Mr. Wallace because he might have looked at her Instagram page. Another example, August 3rd. August 3rd is before Jed was hired. Miss Lively posted a photograph on Instagram of her standing on a New York City sidewalk with a tag that said It Ends With Us movie with a caption stating, "Thank you for having me on Kelly and Mark airs Wednesday." A reference to having just taped an interview live with Kelly and Mark. On August 5th, People published an article titled Blake Lively shares a look inside her New York City apartment with Ryan Reynolds, listing the social media posts that Lively had posted in connection with the Ends With Us promotional tour. On August 6th, Page 6 posted a story titled All the Times interior designer Blake Lively shared a glimpse of her and Ryan Reynolds' rustic New York apartment, listing the many previous occasions on which Miss Lively had shared that information on social media. Anyone engaged in passive observation and analysis of the social media environment as it pertained to It Ends With Us would have been aware of these posts and hence Lively and her family's residence in New York. Okay, so knowing that someone lives in New York doesn't mean that that person has jurisdiction. The court has jurisdiction over that person just because that would be like her saying, well, Katie, you read court documents and you knew I lived in New York, so therefore New York has jurisdiction over you. She also claims that because he remained in close contact with people like Wayfair and he wasn't initially part of the retaliatory lawsuit against Miss Lively, all while fully aware that the Wayfair party's retaliatory countersuit would be filed and was being maintained in New York. Further, given that Mr. Wallace remained involved in closely coordinated work with the other defendants from early 24 to at least early 2025, it is implausible that he would not have learned during that time and certainly prior to the filing of the retaliatory lawsuit and the construction of the related website that Miss Case and Miss Koslow were New York residents actively transacting business in New York on behalf of TAG and otherwise in order to perform numerous overt acts in furtherance of a conspiracy. You know that Miss Koslow and Miss Case didn't make any websites, just so you know. So after 7 months, 8 months of discovery, the best that Blake Lively is able to come up with is that Jed Wallace has and must have known that Blake Lively lived in New York and was doing business in New York. And so anything that he did would have harmed her in New York. And that even passively monitoring her social media means that he was in New York and they have jurisdiction over him. This amendment is an actual embarrassment. If you're going to file an amendment, don't add in claims that were not taken seriously by the judge in the motion to dismiss. You can't use Melissa Nathan's address. You can't use Steve Sorowitz's comments. You can't use the sexual harassment claims you brought up in January of 2024. All of that happened before Wallace. You can't discuss stuff you posted before Wallace ever was hired. You can't say that because he watched your social media, that means he was targeting New York. It means you have, and besides all of that, you still didn't provide any evidence of anything that Jed did directly that harmed you. You can't put him in New York. You can't make the New York courts have jurisdiction over you. Think of the complete chilling and disturbing impact this type of ruling would have if the judge were to say that because Jed watched her and looked at her social media, that the court has jurisdiction over him. That would mean, if he said that that's valid jurisdiction, that any of you could become a victim to a lawsuit of Blake that watches her social media, that leaves a comment on her social media, because you left a comment on her Instagram targeting New York. Think of the kind of message that would send for speech on the internet. No matter how you look at it, whatever direction she takes, Blake Lively's lawsuit is about controlling speech. And, today the Wayfair parties filed this string in that she filed a couple weeks ago. So she's trying to subpoena one of the editors, Rob Sullivan. And I don't know why she's so late to subpoenaing him. She's been literally had 8 months to subpoena this man. But now she's, her amended complaint says her 17-point agreement had nothing to do with her gaining control of the film. She said it's a red herring. But there's evidence from April of 2018, and it's between Henry Grace, Ona, and Rob Sullivan. And Wayfair's asking that the original text that she shared be permanently sealed, and this be the text exchange that can remain on the docket. And it's amazing that they filed this today, because it's almost like a coincidence, and it could be just a coincidence, but it's perfect timing, because her new amended complaints and everything they've said about this being about taking control of the movie is false. And the 17-point agreement had nothing to do with that. They're talking about adjustments to the film, and it has to do with the sex scenes. And so they said, are we keeping the thrust? And there was a side conversation about drinking, but that's not relevant. And Henry Grace, who apparently was one of the individuals, says that's going to be up to Blake. That's going to be a Blake call, honestly. If you can get her to keep it in and it's in the movie, when I get it back, it can stay in. She has approval of that scene. And they said, even for young Lily. And then Rob said, I was just thinking the same. And Henry Grace says, when she claimed she was unsafe, she redid the nudity rider to get approval of young Lily too. What does that have to do with sexual harassment? And Ona said, got it. And Rob said, shaking my head, because she wasn't part of writing that sex scene. And she didn't want a character depicting her to have sex in high school. Honestly, it's all about control, so she could get to where she will be next week. All good. So if she has a 17-point agreement that gives her control, creative control over characters that aren't her, and it's that she doesn't want a character depicting sex in high school, which is strange because she was on Gossip Girl for 6 years and she depicted having all kinds of sex in high school. Is a 17-point agreement about sexual harassment, or is it about controlling her image and controlling the film? And if she gets to decide on editing and the editing cuts, did Sony really just allow her, or was Wayfair forced to sign an agreement that made allegations of sexual harassment, but also at the same time gave her control? And so they're talking about what they're going to add. They're sending videos of, it looks like the scene where it's the assault scene. They're sending back links back and forth. They're editing and talking about adding in, if you or someone you know is experiencing domestic violence, help is available, visit no more or call. They talk about the end of it. If she wants them to say it's a red herring, that she got no control, what does it say? She didn't want a character depicting her to have sex in high school. Is that about sexual harassment, Blake? No. If the character in the book had sex in high school, why did you take the movie, Blake? If this gave you editing control over this, and they said it's going to be a Blake call because you got control after you brought up things being unsafe, and it also gave you more control of the editing process, isn't it not a red herring for the Wayfair parties to, suspect that you did that in order to gain control of a movie? Because right now, this woman has filed a very, very, very embarrassing amended complaint. The same day they dropped these text messages that prove the editors were well aware of how she got editing control, and it had nothing to do with Sony. It wasn't Sony gave her a cut. Is she had to approve it because of the forced agreement she made Wayfair sign. And then another thing that's kind of embarrassing is that Stephanie Jones pulled the data for that website, Stephanie Jones Lies, that she was trying to claim was created by Melissa Nathan or Katie Case or Brianna Koslow from Tag or Jen Abel. Well, the hosting company that hosts this, it shows that a woman named Courtney Engel, who worked for Jones Works and quit in 2023, owned that website. Courtney Engel, who never worked for Tag, never worked with Jen Abel, and works at Magnet Media. So they've been falsely accusing Melissa and Jen of running this website, and they had nothing to do with it, just like they said. And this Courtney Engel is the name that's on the information from the hosting company, the web hosting company. So they're just getting embarrassed, and the evidence is coming out, and yet they still won't give up. So what are your thoughts? Let me know in the comments below. Make sure to give this video a thumbs up. Make sure to subscribe to my channel if you haven't subscribed, and click the bell so you never miss a video. Thanks so much for watching. Bye, besties.